सत्रह तारीख को लिस्ट देख करके या 20 को कर दीजिएगा, 20 को आइटम नंबर 2 वो अभी पेंडिंग है. Yes, what is the case,
Yes.
Mr. Banerjee?
Yes, this arises out of a order passed by the Honorable Tribunal. The petitioner was in the services of Navodaya Vidyalaya Samiti. He was a teacher posted in a Navodaya school in Lohardaga. And at that point of time,
Yes.
there was a complaint against the petitioner that he has molested a girl child during the school hours at about 12:45 a.m. On 11/3/2006, he has molested that girl child, and that on basis of the state complaint, the subsequent day FIR was also registered against the petitioner in the local police station on the statement of the victim. And simultaneously, the petitioner was suspended in view of the provisions in the CCS rules, as he was detained in custody. And thereafter, a summary trial was summary inquiry, resorting to the second proviso to Article 311(2). A summary trial was resorted to instead of a regular inquiry against the petitioner by the Navodaya Vidyalaya Samiti headquarters at Delhi. And pursuant to that summary trial and based on an internal inquiry report, which was never served to the petitioner, the services of the petitioner was terminated. That termination order is dated 9/10/2006.
Yes.
9/10/2006, which is annexure 6 at page 44 of the brief. Lordships, yesterday I have forwarded a list of date and some judgments which are sought to be relied on behalf of the petitioner to both the designated mail IDs of both the honorable courts, and exchanged copy of the said list of dates and the judgments with the learned counsel of the respondents also. And I have also included the judgment which was relied by the respondents before the honorable tribunal, and also referred in the impugned judgment.
Judgments, you have sent this citations or the soft copies?
Soft copies, Lordships. Citations and the soft copies are also attached therein.
Citations, that judgments have not been taken out, but the list of dates is there.
Yes. The judgments were attached with that communication.
Let us see.
Yes, Lordships. The termination order is dated 9/10/2006. That is at page 44. And may I read out the termination order, which is not in course of a regular inquiry. It is on basis of a summary inquiry.
Under which provision of the disciplinary rules, what disciplinary rules apply to your case?
This Central Civil Services Classification Control and Appeal Rules, that applies 1965. That applies to Navodaya Vidyalaya employees also. CCA rules 1965. And Rule 19 is the special procedure in certain cases. Rule 19 is basically in consonance with Article 311 of the Constitution of India. And the respondents have resorted to Rule 19(2), Roman 2 of the CCA rules, which is let's say para materia to the second B sub proviso B to the second proviso to Article 311(2). There, on that issue also, the petitioner seeks to raise up issue that resorting to this procedure is also not in accordance with the rules itself, because for resorting to this, the authority has to record a reason, as the language in the proviso B in the Constitution of India, as also in the Rule 19 says, that where the disciplinary authority is satisfied for reasons to be recorded by it in writing.
Yes.
Although no such reason was earlier communicated, but in this impugned termination order, the disciplinary authority has mentioned a reason that for that purpose, Lordships, may I refer to page 44, that is the termination order, page 44 of the memo of the writ petition.
44.
Yes, Lordships, page 44. It is also accompanied by with a type copy also is also there.
Yes.
This is issued by Navodaya Vidyalaya Samiti, and this is dated October 9, 2006. May I read it out? Order.
Yes.
Whereas a complaint of moral turpitude involving exhibition of immoral sexual behavior towards student was received against K.K. Giri, TGT Maths, while posted at Jawahar Nehru Vidyalaya, Navodaya Vidyalaya, Lohardanka, Jharkhand. And whereas an inquiry conducted regarding these charges has established that said Sri K.K. Giri is prima facie guilty of moral turpitude involving exhibition of immoral sexual behavior towards a girl student of class 7 of JNP Lohardanka. And whereas it is felt that it is not expedient and practicable to hold a regular inquiry under the provisions of Central Civil Services Classification, Control and Appeal Rules 1965 in the matter on account of serious embarrassment it will cause to the concerned students and their guardians. Now, therefore, the undersigned, in the capacity of director, now commissioner, Navodaya Vidyalaya Samiti, in exercise of powers conferred under the provisions of notification dated 20th December 93 of Navodaya Vidyalaya Samiti, hereby terminates the services of said Sri K.K. Giri, TGT Maths, JNV Lohardanka, with immediate effect. Sri K.K. Giri will be paid pay and allowances for 3 months as admissible under the rules in lieu of the notice period. This order, according to the petitioner, it suffers from infirmity for more than one reason. The first reason is that the third paragraph, this recording of this finding, that on account of serious embarrassment which will be caused to the concerned students, there is no such communication with the concerned victim or the guardians that they will not be in a position to attend the inquiry, or there is no such communication. And secondly, there is another aspect of the matter. Since a complaint was already made before the competent court of law, setting in motion a prosecution, a criminal prosecution. So the issue of embarrassment may not be a reasonable reason, because the victim already have moved the competent court of law for initiation of the criminal prosecution. So according to the petitioner contends that this recording of reasons is not in consonance with Rule 19(2), and it is also not in consonance to the proviso to Article 311(2), proviso B. Because the authority empowered to dismiss, he has to be satisfied that for some reasons to be recorded, that it is not reasonably practicable to hold such inquiry. And this reason, according to the petitioner, is not a reasonable reason. That is one issue which the petitioner contends to raise. And the other issue which Lordships the petitioner contends to raise is that some internal inquiry was conducted But the petitioner was never given any opportunity to participate in such internal inquiry, nor he was served with any report of such inquiry, internal inquiry. The said fact has been asserted by the petitioner in the reply to the counter affidavit, because in the counter they have referred to this inquiry proceedings. So this internal inquiry report, neither report given nor the petitioner was given any opportunity in so far this internal inquiry is concerned. And other reason is that there is no finding at all, no reason that as to why this termination would be the only appropriate punishment, even assuming that the internal inquiry committee found the petitioner guilty and the charges, even otherwise the charges are not nasty. It's true that it is not expected from anyone, much less a teacher, to get indulged in such act. But then also the authority in discharge of his powers, he is supposed to record a finding. But the last paragraph, there is no finding at all as to why on the termination and the termination only, because the issue of quantum may also arise as to whether the penalty is proportionate or excessive. So on that both scores, the last paragraph imposing termination, that also does not appears to be sound and not expected from an authority while passing an administrative order. These are the reasons, these are the contentions, reasons and grounds which are sought to be raised on behalf of the petitioner. Apart from this, Lordships, there is another ground, that the criminal case which was filed, in that case the petitioner has been acquitted, though after passing of this, he has been acquitted by a judgment dated 25th of August 2009, which is annexure 8 at page 51 of the memo of writ petition, much subsequent to this passing of this order, but before passing of the statutory appellate authorities order 25/8/2009. And this acquittal was brought to the notice of the statutory appellate authority, as well as it was also brought to the notice of the honorable tribunal. And the acquittal, it cannot be said to be an acquittal by giving benefit of doubt. Rather, the witness did not support the her initial allegation, and in that manner, the learned Sessions Court came to a finding that the prosecution did not prove the case. If Lordship so permits, the judgment of acquittal is there on record. It starts from page 51, marked as annexure 8.
Annexure 8.
8 Lordships. Starting from page 51, and that it is a 3 pages judgment. In the first para records the charges 376 read with 511, and then the allegations, and then the para 2 is about the outcome of investigation, submission of charge sheet. Then para 6, the witnesses are discussed, the evidences. And then after discussion of the evidences of the witnesses and the IO, the page 53, para 8, the arguments, and then finally para 10, I do not find, in view of the discussion, I do not find the accused guilty of the offence under section 376 511 IPC. Accordingly, the accused is acquitted of the charge under section 376 511, and the accused and his sureties are hereby discharged from the respective liabilities of his bail bond. The deposition of the victim is also part of these writ records that has been annexed, that is annexure 15 at page 64, Lordships. The deposition made by the victim.
She has been declared hostile.
Yes, she has been declared hostile. That is true. Page
64, annexure 15.
Yes, Lordships, and there is a type copy is also there, Lordship, because it is handwritten. The statement which is before this statement is on this deposition is on oath, and so it has a legal sanctity. Para 4 of the deposition in chief, what is deposed is that कि मैं दिव्या हम दोनों यूनिट टेस्ट का नंबर जोड़ने लगे, दैट इज पेज 64 पैरा 4 ऑफ द डिपोजिशन. हम दोनों फिर यूनिट टेस्ट का नंबर जोड़ने लगे, तो सर बाहर गए एवं अंदर आ गए. दोनों कोई देखो, दोनों में जाकर कोई देखो कि क्लास में कोई स्टूडेंट है कि नहीं. तब दिव्या चली गई, हम निकलने वाले थे तो सर हमसे टकरा कर हमें बचाने हेतु पकड़े. मैं डर गई, फिर भाग गई. सो दिस इज द सब्सटेंशियल एविडेंस before the competent court of law in course of the criminal prosecution. And apart from this, so this also appears to be a relevant fact which may be considered for the purpose of adjudication of the legality of the termination order. Though the standard of proof are different in a departmental inquiry and criminal case, that is true, but there is more stringent requirement under in a criminal proceedings where the provisions of Evidence Act applies. And in such view of the matter, where Indian Evidence Act applies, the prosecution did not prove, and even there is no such recording about preponderance of probability or something in the impugned order.
It is a detailed summary trial.
True, Lordships, but the main thing is that the requirement for holding a summary trial, that should be satisfying the constitutional mandate, and similar is the rule based on the constitutional mandate, rule 19(2). But this reason that in the matter on account of serious embarrassment, this reason of the disciplinary authority does not appears to be supported by any proper basis, because in such an event, serious embarrassment inference could be drawn that had the victim even not moved the court of law or not appeared to give any deposition or something, and even there is nothing brought on record that the victim or their family members they communicated that they will not be in a position to give any evidence in course of departmental inquiry. So that is one aspect which this honorable court may kindly consider as to whether resorting to this second proviso small b of the article 311 to be read with rule 19 Roman 2 is justified, and the reasons is reasonable. That is one thing. And then the other aspects which I mentioned, the reasons because of which the impugned order may not be found to be sustainable, that there is no discussion at all in the impugned order except for the internal inquiry, in which the petitioner was not given any such opportunity, nor the copy was served to the petitioner. And alternatively, on the issue of quantum also, there is no such discussion as to why his termination is only punishment which could have been imposed. And on this aspect, if Lordships allows on the proviso that not holding regular inquiry, it has been held by the Honorable Apex Court that that is an exception. It is normal course is holding a regular inquiry. What's 1 is 2005 volume 11 SCC 525. 91.
Where is the inquiry report?
The inquiry report, they have brought it along with the counter affidavit because
Running
copy of the
103. Running 103.
yes.
Running?
103 of the brief.
Oh,
And findings are at 107.
Not a case for interference, Mr. Banerjee.
Uh, True, Lordship. Only I was making submissions, therefore, in respect of those issues that the basically the technical issues, because on merits I do understand that the nature of the case is nasty and on that, but the provision of Article 311(2) is normally resorted to. and dispensing with the regular inquiry is an exception. And here, dispensing with the regular inquiry, which is being questioned by the petitioner, is not based on any objective facts. It only appears to be a baseless finding that there would be embarrassment. There is no material or nor any communication to substantiate that
That is a very
finding.
genuine ground. Embarrassment of a girl.
But lordships, there should be, as the honorable courts from lordships has time to time held, as also recorded in paragraph 5 of the judgment reported in 1991 volume 3 Supreme Court cases, also in the case of Sudesh Kumar in 2005, that there should be some basis, because it is an exception is being resorted to. So mere formation of an inference without any basis, and this formation is not supported by any independent material to justify dispensing with the inquiry. That is one aspect, and other aspect, lordships, which I was praying that in matters of disciplinary proceedings, the judicial review, at least the issue of quantum may be examined, as to whether the punishment is proportionate and as to whether the disciplinary authority has has properly applied his mind.
Your argument about natural justice, etc., has been given, has been replied in paragraph 8 of the judgment of the coordinate bench of this court, which has been annexed as in counter affidavit as.
Yes, lordships. I've seen that. And based on the Avinash Nagara case, lordships,
Yes.
1997, which is also relied, and
Para 11, 12 has been relied.
yes, true, lordship. That is there. These are the pleas which I am raising, but the issue of quantum and another aspect, that the termination order, it doesn't forms any opinion, and an administrative order is being passed. A disciplinary authority, he is exercising his burden. A decision to terminate someone, causing it is a civil action, and there at least some kind of deliberation, that some kind of reasoning, no independent reasoning, no finding is there in the penultimate operating para of the impugned order. Nothing is there, and much less on the quantum, as to why only the termination, as to why not some other punishment, which in lieu of this termination. So these are the things which appears to be overlooked and absolutely not considered by the concerned disciplinary authority, and it has also not been appreciated by the honorable tribunal, this aspect of the matter. And so far as that acquittal in the criminal case is concerned, that is subject to consideration of lordships, but there before the court of law, the victim has deposed otherwise, and that deposition also has a legal sanctity. That is a deposition on oath before a competent court of law in accordance with our judicial system, and so there is a statement which is contradicting the findings in the internal inquiry. That is one thing, and these are the only pleas which can be raised on behalf of the petitioner, subject to your lordship's consideration. And one thing, that he completed 11 years of service. Thereafter, all this happened. He has mentioned all this thing in his so cause. And another point which I should bring to the notice of this honorable court, that the so cause he submitted during summary trial, there is no consideration to the so cause, because had there been a single line termination order that the cause shown is not sufficient, or the disciplinary authority is not satisfied with the cause shown, even that line is not there in the order of the disciplinary authority. This is all lordships subject to lordships consideration.
Not a case for interference.
As your lordships will be. My submissions only may kindly be considered and recorded in the. Yes.
Third level counsel for the petitioner, Mr. Ratan Banerjee, and Ruby
Yes,
Pandey.
now for the respondent number 5,
Number
Milord.
5. Petitioner, a TGT maths within bracket teacher.
Milord, my submissions, Milord, I would like to say 2 points, Milord. I have annexed a judgment in my counter affidavit. That one is completely covered, Milord. That one is annexed
We have
R by
seen
3.
that. We have seen that. We will record your submission.
Yes, yes.
Of Jawahar Navodaya Vidyalaya Lohardaga was terminated from service with 3 months pay and allowance on grounds of proven moral turpitude involving exhibition of immoral sexual behavior towards a girl student of class 7 after a summary trial in terms of the provisions of the Central Civil Services within bracket classification control and appeal rules bracket close 1965 and as permissible under Article 81 capital B within bracket of the Kendriya Vidyalaya Sangathan Code. Stop. In the criminal trial, ST case number 64 of 2006, prosecution witnesses number 1, 2, 3, 6 and 7, all students of the Jawahar of this Vidyalaya, Jawahar Navodaya Vidyalaya were declared hostile. Stop. The informant victim PW3 was also declared hostile. Stop. She had stated in her examination in chief that she accidentally dashed against the accused teacher, who then caught hold of her, by which she was frightened and escaped. Stop. PW4 and PW5, two teachers of the school were hearsay witnesses. Stop. The petitioner was acquitted of the charges under section 376/511 of the IPC by judgment dated 25th August 2009, passed by learned Assistant Sessions Judge Lohardaga in ST case number 64 of 2006, arising out of Sinha PS case number 27 of 2006 within bracket GR number 125/06, registered under section 376, 511 of the IPC within bracket annexure 8. टर्मिनेशन ऑर्डर का एनेक्सर 6, यहाँ टर्मिनेशन ऑर्डर लिखे थे, शुरू में जो लिख रहे थे ना, October 9, 2006. The learned CAT in an earlier round of litigation upon his acquittal directed the competent authority to take a decision on the applicant's appeal as well as subsequent representations filed by him by passing a speaking order, reason and speaking order, by order dated 18 January 2013, passed in OA number 218 of 2012 R. Within bracket annexure 12. Upon reconsideration, the Commissioner Navodaya Vidyalaya upheld the order of termination, but order impugned in the OA dated 25th June 2013, annexure 14. Stop. The Commissioner Navodaya Vidyalaya held that the departmental and criminal proceedings are two separate proceedings, and acquittal in the criminal case does not necessarily imply that the charged officer should invariably be exonerated in the departmental proceedings. According to the competent authority, the learned Sessions Court Lohardaga had not acquitted the petitioner on merits but on technical grounds, as prosecution witnesses became hostile and the victim girl herself backed out. And moreover, the teachers deposed that the offense did not happen before them or in their presence. It was held that the competent authority held that his services were terminated for violation of the code of conduct of a teacher in a residential system of school. Stop. On being challenged, learned CAT, Patna Bench, Circuit Bench at Ranchi, did not find any merit in the grounds to interfere in the penalty of termination from service, by the impugned order dated 1st March 2016, passed in OA number 051/0015/2014, annexure 19. Stop. Then counsel for the petitioner has made twofold submissions. One, that there is no objective basis on which the subjective satisfaction of the competent authority to dispense with a regular inquiry has been arrived at. Stop. Arrived at as per the constitutional requirement under Article 311 proviso small b. Stop. He has relied upon the following decisions in support. In 2005, 11 SCC 525, 2006, 13 SCC 581, 2014, 13 SCC, page 244. Subpara. Petitioner was denied reasonable opportunity to defend himself, resulting in violation of principles of natural justice. on account of dispensation of the regular inquiry. Stop. No cogent or specific grounds were shown on the part of the disciplinary authority to dispense with a regular inquiry. Stop. Small subpara. The departmental summary trial, the summary inquiry was held for the same charges for which he was tried before the criminal court, before the sessions court. Stop. The charges were on the same set of facts, based on same set of facts, which the prosecution witnesses, including the victim, did not support. Stop. In such circumstances, relying upon the case of M. Paul Anthony
Yes. Just 1999, Volume 3, Supreme Court cases.
1999, Volume 3, SCC, page
679, Lordships.
679.
Chennai.
It is para 13.
Yes.
It is submitted that though in the departmental proceedings the standard of proof is one of preponderance of probabilities, in a criminal case the charge has to be proved by the prosecution beyond reasonable doubt. The little exception that may be made where the departmental proceedings and the criminal case are based on the same set of facts and evidence. In both the proceedings are common without there being a variance. The petitioner, the penalty of termination imposed upon the petitioner ought to have been set aside or recalled by the disciplinary authority. Stop. This subtle position in law has not been properly appreciated by the learned tribunal. Next. It is submitted that even if the charges are assumed to, even if assumingly the allegations, even on the basis of the statement of the girl made during criminal trial, is assumingly taken to be true. Submission, the counsel for the petitioner has called for an interference in the impugned orders. Stop. The counsel for the respondent Vidyalaya, respondent number 5 Vidyalaya, has taken us through the counter affidavit filed on their behalf. It encloses the report of summary trial as annexure R/1, during which the constituted committee took into account the statement deposed by the petitioner before inquiry committee on 11th March 2006 conducted at regional office level, semicolon, the statement of three girls, including the victim, the preliminary inquiry report dated 21st March 2006, submitted by Assistant Commissioner within bracket SA, and the statement of the petitioner before the committee recorded on 14 July 2006, the statement of the victim girl and the findings of the duly constituted committee, which concluded that the petitioner, which concluded on the basis of the relevant records available before it, that the petitioner had made an attempt to victimize the teenage girl studying in class 6 in the residential school by molesting her and making an attempt of sexual advances on 11th March 2006 while being alone in maths lab during 7th period. Stop. Learned counsel for the respondent has tried to dispel the contention based on dispensation of the regular inquiry by the regular inquiry based on the judgment rendered by the coordinate bench of this court in the case of a similar nature concerning misbehavior towards a girl student of class 8 in Kendriya Vidyalaya Sangathan School at Chakradharpur. In WPS number 221 of 2007, judgment dated 1st December 2008, annexure R/3. Stop. Article 81 of the Kendriya Vidyalaya Sangathan Code permits termination of services in certain cases through special procedure. Stop. It is submitted that the decision of the disciplinary authority to dispense with regular inquiry was well informed and made on due consideration of the objective factors that such an inquiry, regular inquiry, would result in embarrassment not only to the teacher and students of the institution but also bring the institution in disrepute, where the teachers and the students, including the victim, may have to undergo lengthy cross-examination in open. Stop. The conduct of the employee did not warrant, the petitioner being a teacher of the school, it was likely that such an inquiry would get influenced by his position. Stop. The reliance is placed upon the decision of the apex court in the case of so and so 2004 13 SEC 568, and also in the case of so and so 1997 2 SEC 534 and so 2004 13 SEC 568, both relating to misconduct by a teacher with a girl student in a Navodaya Vidyalaya. Where the dispensation of regular inquiry as per Article 81 of the Kendriya Vidyalaya Sangathan Code was upheld. Stop. Then counsel for the respondent has, by referring to the decision of the coordinate bench of this court in the case of Kendriya Vidyalaya Sangathan and other Supra, submitted that in matters of discipline and conduct of the teachers and students, this court would be loath, L-O-A-T-H-E, loath to interfere in termination of services of a teacher like the petitioner, whose conduct has been involves moral turpitude, whose conduct involves exhibition of immoral sexual behavior towards a student, amounting to moral turpitude. Moral turpitude. Stop. They submitted that the learned tribunal has not found any good grounds to interfere, therefore not found any good grounds to interfere in the order of termination, passed upon reconsideration after his acquittal in the sessions trial also. So, we have considered the submission of learned counsel for the parties, taken note of the materials placed on record, and also perused the decisions cited by the parties. Stop. At the outset, it can be straightaway observed that the acquittal of the petitioner was not based on merits, but caused by important witnesses, including the victim, turning hostile. Important witnesses like fellow students and including the victim turning hostile during trial. Stop. On the other hand, though the charges in the criminal trial were based on same set of facts. However, it is also evident from perusal of the inquiry report of this summary inquiry summary inquiry of the report of this duly constituted committee in the summary inquiry that petitioner got reasonable opportunity to defend himself and also address the inquiry committee on the preliminary inquiry committee report dated 11th March 2006, as also the statements of the victim girl and other two girls. Inquiry committee report at 21st March 2006, preliminary inquiry committee. Stop. A perusal of the report of the duly constituted committee dispels the impression that petitioner did not get reasonable opportunity to defend himself. Stop. The para. The present case also concerning a teacher of a Kendriya Vidyalaya like that of in WPS number 221 of 2007 and those of Avinash Nagra Supra and Director Navodaya Vidyalaya Samiti Supra stand on similar footing as all relate to misconduct against a girl student by the teacher of this school, where the requirement of regular inquiry was the dispensation of regular inquiry was upheld. Stop. It would be appropriate to quote the opinion of the Apex Court as to the rationale for dispensing such a regular inquiry. ये पेज रनिंग पेज 122 से ये पोर्शन को ये जो जजमेंट कोट किया हुआ है इसमें ये है अविनाश नागरा का पैरा 12 से इसको कोट करना है, पार्ट ऑफ पैरा 12. Similar view has been taken in the case of Director Navodaya Vidyalaya Samiti following the decision in the case of Avinash Nagra at paragraph 10 of the report. Stop. Then Council, we therefore reject such contention of the petition made on behalf of the petition. Stop. In the nature of misconduct, in the light of the misconduct committed by the petitioner, whose position as a teacher respected in the Indian society as, within quotes, Guru Brahma, Guru Vishnu, Guru Devo Maheshwara, quote, does not commend us to, do not persuade us to accept the contention that the punishment of termination from service was shocking to the conscience of the court on grounds of proportionality. The discipline of the institution, discipline in the institution, and the discipline and sacred requirement of an educational institution has to be preserved. So, if the faith of the students in the teacher themselves get eroded by such misconduct, there would be no other sacred place for imparting education to the students of nation. On due consideration of all the rival submission of the parties, in light of the facts and circumstances and materials on record, considered in the light of the settled principles of law, we do not find any substance in the petition. It is accordingly dismissed.
My Lord, may I only pray for incorporating in my submission the plea which I raised, one plea, that neither there is any reference to the cause shown in the so cause, nor there is any independent finding or opinion of the disciplinary authority in my submission.
Neither there is in the cause what?
Neither there is any reference to the cause shown by the petitioner in his so cause, nor there is any independent finding or opinion of the disciplinary authority.
Then counsel for the petitioner has argued that the impugned order of termination did not refer to the specific reply contained in the show cause of the petitioner, nor any such consideration has been accorded to it.
To that effect, my submissions, Milord. To that effect, I would like to reply, Milord. In that cases, Milord, so-cause notice has been provided, served to the petitioners, Milord, that has been in Annexure 4, Milord. dated 27 and 2006, my lord.
Very well.
And my lord, only one lastly, the reference to 91 volume 3 SCC that has perhaps not been.
जसवंत सिंह केस
Yes, just one thing. Para 5.
उसमें जहाँ 3 तो 2005 से साइट किया था,
Higher lordship, sir.
Yeah, that is there, that is there.
Incorporated. Only just one thing's 91 volume 3.
जसवंत सिंह वाले का ऐड कर दीजिए वो एक
91 volume
1991
1991 volume 1 SCC 362.
हाँ
Paragraph
C 362 पैराग्राफ
5 placitum G and H. Paragraph 5 placitum G and H.
पैराग्राफ 5 वही जहाँ 311 2B का जहाँ जजमेंट चार्ट हो
And lordship, sir, division bench judgment which I have sent our honorable court 2002 volume 3.
और एक डिवीजन बेंच का
That soft copy I have sent 2002.
उसी के नीचे में ये सुप्रीम कोर्ट के जजमेंट के बाद इसका भी दे दीजिएगा रेफरेंस 2002 3 JCR 213 within bracket JHR.
Yes, para 5.
JHR and others versus Javed Saukar.
Yes, paragraph 5, lordship.
Paragraph 9.
5, lordship. 5.
Very well.
Grateful, lordship.
Okay, brother. Thank you.
Okay, Pranam.
Grateful, lordship.
Yeah.